Hi there. We've had in the last few weeks, we've had two significant High Court cases which affect massively both trans people, service providers, and also employers. And so we want to give some guidance. And with me, but who better than my good friend and employment and discrimination barrister, Robin Moira White. Hello again, Robin.
Good afternoon.
We seem to be making a habit of this, Robin, don't we?
Ah, well, there you go.
It's not that bad talking to me, is it? So there's two particular High Court cases that we want to discuss today. So the first, let's deal with the great news first of all, on the case with the Hampstead Heath ponds.
So that was the anti-trans organisation Sex Matters' attempt to judicially review the Corporation of London's decision because they, for arcane historical reasons, they are the body that manages the swimming ponds on Hampstead Heath. And albeit that 86% or something of the users wanted to be trans inclusive, Sex Matters want them not to be trans inclusive.
And it was a big poll as well, wasn't it? Was it
Oh yeah, it was a
38,445
lot
people?
of results, and
A
indeed
lot.
it was quite entertaining to have Sex Matters jumping up and down saying that some of these people might not use the ponds when Sex Matters polls that they run, they wheel out their membership to express a view about something that the membership are just not involved in at all. So, and they were critical of somebody running a poll in exactly the same way, but it's less significant than some people have jumped up and down about, because what the judge effectively said is that Sex Matters don't have standing because they don't have sufficient interest to bring a judicial review claim,
Mm.
and a claim is much more viable from either a user or somebody who would have been a user. So broadly, wrong claimant. It doesn't mean to say that somebody else subsequently might not
Yeah.
bring a claim as a potential user.
Yeah, I don't think we've
So
heard the last of it, have we?
I doubt it.
So,
But there's a bit in the second case that we're going to talk about, which is the Good Law Project Judicial Review.
yeah.
I, being an active litigation person, as we barristers tend to be, somebody years ago, we had a new clerk join Chambers and said, asked whether we all do litigation. Yes, we're all barristers, so we just think about fighting in court all the time. Um, and I often come from that perspective, and I think that's the eye that you need to bring to these cases.
Okay.
Is somebody going to succeed?
Yeah.
And I've been
Okay.
saying for a while that the way to defend these cases is to make sure that there are facilities available for people of all stamps and views
That's
who can be accommodated,
that's
and
exactly.
that's what we're going to come to in the second case.
Yeah. So the second case, so this is what I was originally going to say, the good news and the terrible news, but then you corrected me when we were having a chat before this recording started. So this is the case of Good Law Project versus the Equality and Human Rights Commission. And that judgment was brought about this week. So do you want to tell us a little bit about that?
Yeah, and what's important to say is that this was a challenge by the Good Law Project to the interpretation put out by the Equality and Human Rights Commission in the hours following the Supreme Court judgment back in April.
It was
And
so
this was
quick, wasn't it?
well, it was an interpretation written by the then Commissioner Aqua Reindorf, KC, and put in place on the website by Kishore Faulkner, the then chair. And it was used that the use of that interpretation was that there should be instant exclusion of trans people from pretty much every facility in the country. And one or two employers jumped about that as well.
Quite a few have,
Um,
haven't they? Yeah.
and I think what people have suddenly realised is that the guidance that's being worked on by the Equality and Human Rights Commission is about services, public functions, and associations, not workplaces. And
Yeah.
there's no sniff of new guidance on workplaces coming from the Equality and Human Rights Commission at the moment.
Yeah.
The judge has said that the guidance produced wasn't unlawful, but he's not shall we say, very supportive of it. He's not. He doesn't jump with glee and say how wonderful it was. He was being asked to strike it down and says, well, it doesn't quite get to that level. But
Okay.
what he does do is look at, for example, the circumstance where a service provider says that they're going to provide a service to women with a rather wide meaning of the word women, so they're wider than the Supreme Court um, took it to mean. And they're going to include biological women and trans women in their definition of women. And the analysis that I like, and I think is one that needs to be carried through, and we're going to talk about in respect of employment again in a moment, is who would sue in that circumstance? Who would be unhappy? And the suggestion is that cis men would be unhappy because they would be excluded from the women's lavatory in the cinema in the service provision location. Now, to succeed, they don't have to just show a difference of treatment. They have to show less favourable treatment. And if the men's is like 10 feet along the corridor, how are they going to show that it's less favourable treatment to say the cinema owner says that you need to go in there,
Yeah.
and you need to go in there with the trans men who look like men
Yeah.
and use the facilities as men? And so it's going to be extremely unlikely that anybody could bring a successful claim against a service provider being inclusive. And there's nothing that prevents a service provider being inclusive either. Now, that's the service provision. There's then some discussion about what the circumstances related to employment, and there is this is once again this is another first instance decision like Kelly and Peggy and Hutchison, which is the Darlington nurses case.
Yeah.
And what the judge has said is that the 92 regulations about provision of workplace toilets and changing rooms should be interpreted in the same way. He couldn't see any reason why it shouldn't be interpreted in the same way as Form in Scotland has interpreted men and women under the Equality Act. But back to my analysis, if an employer turns around and says, well, I'm going to allow trans women to use the facilities at work, arguably that's a breach of Section 20 of the 92 regulations. But an individual can't sue under the regulations. It doesn't provide a right of action for an individual.
Right.
And in the same circumstance, in using the same analysis as services, who's going to sue? So what, the cis man who's got to walk 10 feet along the corridor?
No, he's not going to.
Or
Yeah.
now, the more likely claim would be by a cis woman, gender critical woman, who doesn't like the idea of sharing with a man. But if there's an accessible toilet facility close by, then is she likely to succeed? Probably not. Now, Mr. Justice Swift in the GLP case said, well, it's not. He looked at the circumstance of a trans person who's saying, I'm excluded from the gender appropriate facilities. And one bit of that judgment I'm particularly unimpressed by is that he talked about the fact that somebody would be exposed to gossip.
This is in the workplace. This is in the workplace, isn't it?
In the workplace, if they're instructed to use separate facilities. Well, I'm sorry to say that's not a proper understanding of the position, because somebody, firstly, they have their data rights and they might be outed. They might have rights under the Gender Recognition Act.
It's really serious, isn't it?
It's much more serious. And therefore, in my view, it's much more likely that that person could succeed in saying, I've been forced to use the separated facilities. So, but what that actually does, it puts potentially the employer in legal terms between a rock and a hard place, because the 92 regs say one thing and potentially equality law says another thing. And that might have to be resolved in court or tribunal somewhere. If we had a government with sense and courage, well, what they would do is resolve that situation. But I'm afraid to say I think we're left with a situation where there is, guess what, likely to be more litigation.
There's going to be loads more, isn't there? It's a complete mess, isn't it? Total mess.
It's, I mean, it just shows, it illustrates, I think, what Melanie Tether, the civil servant who was involved in um, producing the Equality Act back in 2010, has said very equitably, is this shows the difficulty created where the Supreme Court comes up with an interpretation that was completely different from the intention of the people who created the legislation in the first place.
Yeah.
Well, arguably, one might say the Supreme Court's job was to follow the interpretation of the people who produced the legislation in the first place. So there continues to be a mess. Employers continue to be the meat in the sandwich. Another good bit is on a Judge Swift's judgment, was to remind people that trans people have rights and are a protected characteristic, and whatever arrangement is come to has to provide them with appropriate facilities. Now, we might disagree with his view that ghettoizing trans people is providing appropriate facilities, but it's by no means a straightforward position. And let us hope that with the departures from Downing Street that we've seen in the last couple of weeks, some more sensible voices in to see the Equalities Minister and explain, that proper things have to be done to accommodate people. And there are practical, sensible solutions out there.
Yeah, absolutely.
And, government ought to engage with people. There are two sorts of people involved in this discussion. There are people who don't want a solution, they want exclusion.
Yep.
And, we could identify which organisations we think they are. And there are other people who certainly have skin in the game. I certainly have skin in the game, but can see that there are practical solutions that would accommodate everyone's needs. And I've been promoting this idea of the availability of enhanced privacy for those people who want it as being a solution that works, and just has to be worked through. And we just have to make sure that legislation and guidance allow that. And it's not difficult.
No. So,
and why would you resist that?
Absolutely. So basically, in a nutshell, then, for in terms of service providers, the judge confirmed that there's not a trans bathroom ban, and so trans women can use the women's loos that are just marked women. They don't have to be marked anything else or anything, and trans men can use men's loos. And it's not unlawful for service providers to provide those facilities, and they don't have to police it or anything like that. So there's nothing like that from that point of view. And then in terms of
but very helpful if the service providers have as well one or more what are known as universal facilities.
So that an individual,
anyone who doesn't like the idea, or there are people for religious reasons who
of course,
keen on. I mean, for them, where the sex split is very important for their religion. If there is a facility where they know they can go and use and be certain that they're not going to be sharing the facility with anybody who they wouldn't want to share it with, then that is a complete solution.
And so that's service providers, and in the workplace, that's essential, isn't it?
Well, in the workplace, that's there's at the moment there's something of a clash with the workplace regulations as interpreted by the judge. Other people would interpret them differently, and it should be remembered that the Good Law Project are saying they're going to appeal those aspects of the judgment. So we'll see where that goes. But that's the advice I'd be giving to employers, to act rather like the service provider we were talking about, which completely minimises the chance of being sued by anyone.
So really, these cases haven't really changed much at all, really.
That would be my view, but obviously, yes, there's more litigation to come, and the very nature of these cases is that people can take different views about the outcomes of them.
Thank you very much, Robin.
You're welcome.